So is the screen visible?
Yes, sir.
Raghavendra. Raghavendra, please start.
Yes, sir. Good morning, everyone. So the topic given to me today is issues in rental of commercial immovable property. So I'll just renting of the topic says issue rental of commercial immovable property. So I have not gone depth into residential property. Residential property. First, we need to distinguish between what is commercial versus residential use. In to my from what my understanding, the terms commercial, neither commercial nor residential has been specifically defined in the Act. So we need to look into other sources to figure out what exactly do they mean by these words. When I started to refer the other acts by themselves also do not give any specific definition, like Transfer of Property Act, Registration Act. Registration Act is only for the purpose of just for document registration. Transfer of Property Act does not give any specific clarity as to how to distinguish between a residential property and a commercial property. So the criteria that which we could take is basically two. One is what is the there are few criteria basically. One first is what is the permitted use. You can go by what is the permitted use for the property. Meaning permitted use meaning uh, either by way of uh, lease deed, what the deed mentions, what the document mentions, or even if the document mentions it to be a residential property, still if an NOC is given by the owner for GST registration purposes, it could still be treated as commercial property. This is one way of understanding whether a property is a residential property or a commercial property. There are some other considerations which practically we are using, like assessment by municipal tax authorities, how the property tax, how it is mentioned in property tax, how it is mentioned in electricity EB bill or water tax, etc. But to my understanding, I think what the lease deed says, what you call as permitted use. Permitted use would be a better scale to decide whether something is a commercial property or a residential property. The second alternative would be actual use. What exactly actually is the property used for? So when it comes to choosing between these two, permitted use versus actual use, for GST, in my GST, whatever, there are two varying arguments. One argument says that permitted use presides over actual use, but to my understanding, I think the actual use forms actual use is what is to be taken up for deciding whether a property is a commercial property or a residential property. So before entering into the case studies, does anyone have any question or any other discussion on this point?
Go ahead.
Okay.
Unauthorized use also will be a question, but go ahead.
Unauthorized use. Okay. So is it dependent on permitted use or actual use? Even there is a service tax education guide, which facts, which is way back in 2017, which has somewhat given a meaning of the term residential dwelling. So this is exactly the term which we are going to look into in the entries. So residential dwelling, it's not defined in the notification also. It is not defined in exemption notification, but the word used is residential dwelling. A fact under service tax regime says the phrase residential dwelling has not been defined in the Act. It has therefore to be interpreted in terms of the normal trade parlance, as per which it is any residential accommodation, but does not include some exclusions, hotel, motel, guest inn, etc., etc. Even here, it does not give a very clear picture. It says as per normal trade parlance. So, for our discussion today, um, uh, actual use is what is I consider a better. To my understanding, actual use is what is to be used to decide whether something is a residential dwelling or not. So, based on this first understanding, um, when it comes to uh, renting or leasing service, there are two specific uh, one entry in exemption and two specific entries in RCM notification, which we are going to come back to again and again. So the first is entry number 12 of exemption notification 12/2017 CTR, and 13 it is 5AA and 5BB. So we will come back to this once we start off with the cases. Moving forward, case study 1. It's a basic case. So uh, first, I will list out all the cases wherein a residential dwelling is given for a commercial purpose. A residential dwelling given on rent for commercial use to an unregistered person. So first, entry number 12 of exemption notification. If we look at the first, let us decide whether this is a residential dwelling as per our understanding. So the actual use is for business purposes. So it cannot be called technically as a residential dwelling.
Ravindra, can you project the screen and PPT?
Full screen, sir.
Yeah, full screen.
Full screen. Okay, now, sir.
Okay, thank you. Continue.
Okay. So entry number 12 reads as services by way of renting of residential dwelling. So when we, for the purpose of checking this entry, this residential dwelling, the word, we need to see whether what is the actual use of the property by the tenant. In case 1, the case itself is given for rent for commercial usage. So a residential dwelling is given for commercial use. Actual use itself is commercial. So this cannot be treated as a residential dwelling for the purpose of this entry, which means this exemption entry will not apply. That's what my understanding. So this exemption entry will not apply. Property not a residential dwelling for the purpose of this notification. Which means it will be taxable. So to check whether RCM is applicable or not, there are two entries under RCM notification 13/2017. 5AA, which talks about service by way of renting of residential dwelling to a registered person, and 5AB, which is other than residential dwelling. So now in present case, since the property is not a residential dwelling, it will fall under, we have to check whether 5AB is applicable. AB is service provider is any unregistered person, recipient is registered person other than the person who has opted for composition levy. So here the recipient is not a registered person, tenant is not a registered person, so this RCM notification is also not applicable. So the taxability will be in the hands of the uh, owner. If he crosses the threshold limit, he will be liable for registration and liable to pay RCM under forward charge. Sorry, for pay tax under forward charge. So any question or any discussion on this? Can I proceed?
Proceed, proceed.
So this is just an expansion of the case study seen now. So case study 2, residential dwelling given on rent for commercial use to a registered, a regular registered person, meaning GST is a normal GST register. So here again, same entry number 12 exemption will not apply for the same thing discussed above. Entry 5AB will apply because since now the tenant is registered, so RCM under 5AB will be applicable. So it is taxable under reverse charge. However, if the owner is registered, then he will be liable for a forward charge. Same notification will not apply. Another variant is case study 3, is residential dwelling given on rent for commercial use to a composition registered person. Tenant is registered as a composition dealer. Here again, the exemption will not apply, and RCM entry will also not apply because there is a specific exclusion in the entry 5AB. Any registered person other than a person who has opted to pay tax under composition levy. So once again,
Raghavendra,
sir.
see, you're providing basic information.
Okay, sir.
All are experts.
Okay,
Tuesday
sir.
morning are all full of experts only.
Okay, sir.
So no basics, please.
Okay. So in this case, it will be taxable under forward charge. Next scenario, RCM on a rental expense where outward supply is fully under RCM. Example GTA. A person registered who has no outward supplies other than RCM outward supplies. He is taking a place on rent, and what would be the taxability? So the point for consideration is exclusively RCM outward supply is not liable for registration as per notification 5/2017 issued under 23(2). But there is also a compulsory registration as per 24 because of RCM. Whenever there is a conflict between 23(2) and 24, 23(2) specifically overrides 21, 22(1) and 24. So 23(2) exemption will prevail. So there is no requirement for registration, even if the threshold crosses, is my understanding. There is a variation to this case law, case study, meaning what if the outward supply is fully under exempted? Exemption, I'll get back. I've added the case law in the subsequent slides. Coming to valuation issues. shareholder of a private company or a designated partner of an LLP, he gives his own place for usage with a no objection certificate. There is no rent collector, there is no rental agreement executed. For the purpose of GST, an NOC has been obtained and registration has been obtained. So whether this will be a taxable supply, first, whether it will be a supply, yes, it will be a supply even if it is without consideration, because uh, both company and the shareholder becomes a related person. So schedule 1 entry 2 is supply even if without consideration, and entry 5AB, since the recipient is registered, again entry 5AB of RCM notification will apply, assuming it's a regular registration. And transaction value would be the key discussion in this. Okay, taxable value will not be transaction value because the parties are registered, and so market value will be considered. So in this case, it will be a taxable supply. RCM will apply. So the company has to pay RCM on the market value of the property. So even if we give a no objection certificate, still for the purpose of there will be no entry in the books, but GST sake, we have to pay tax under RCM and claim ITC. So next, case study 6. Firm runs a hotel with a composition GST number at the property of the partner with NOC from the partner. Here again, it is a supply. It will fall under schedule 1. Once again, RCM notification here will not apply because there is a specific exemption, specific exclusion of composition dealer. So in this case, it will be taxable under forward charge, and threshold limits will apply. If the owner is cross the threshold, then he has to register and get registration under GST and charge GST in the forward charge. The third variation for NOC is proprietor who has GSTN at residence with NOC from spouse. Once again, this is supply, schedule 1. RCM will apply, entry 5AB will apply because now the tenant is a registered person. Valuation, again, it will be not be transaction value, it will be open market value. But here the point to be noted is registration for all practical purpose to be obtained, but residence may not satisfy the place of business definition nor the fixed establishment definition. So this is a litigative point, whether the department may question this, whether residence can be a place of business or not. So until this, any questions until this, any discussions?
Continue.
Okay. Next variation is an advocate runs an 800 square feet office in ground floor by residence owned by the father. Property is under HUF property. So again, it will be a related person. The same schedule 1 holds good. Outward supply, since it is exclusively exempt outward supply, the variant of what we saw earlier, he will not be liable for registration, but now it is not under 23.2, it is under 23.1. And compulsory registration as per 24, since RCM is applicable, 24 class 3 compulsory registration is applicable. See, now the conflict is between 23.1 and 24. 23.1 does not have a notwithstanding provision. 23.2 specifically has a notwithstanding provision, which means 23.2 will override, whereas 23.1 will not override 24. So he will be liable for registration. 24 compulsory registration is applicable, and value will not be transaction value, it will be market value. So it is taxable under forward charge, and registration should be obtained compulsorily by the advocate. Next variation is house rented by private company for residence of director. Obviously, entry number 12 exemption entry will not apply because recipient is a registered person. And here, since the property is a residential dwelling, RCM entry will be 5AA. 5AA will apply because any person and owner is any person and tenant is a registered person. Whether the so it will be taxable under reverse charge. Company has to pay ITC, but the question here is whether it could be treated as for the purpose of business or not. So ITC restriction, in my view, 17.5G personal consumption, ITC will be restricted under that clause. So it is, but it is again an open point. Whether this 17.5 restriction will apply or not is yet to be tested. Next variation is director's own house rented to the company to give back as rent-free accommodation. Director owns a property. So from company's point of view, it will again be a Schedule 1 entry. Entry number 12 of exemption notification will not apply because recipient is registered. So it is a taxable supply. And since it is a residential dwelling, RCM to be tested under entry 5AA. Again, it is applicable since registered recipient. So the company will have to pay RCM for the but value here will not be determined since it is director's own property. Valuation will be market value. But once again, the restriction under 17.5G might come into play. It's a rent-free accommodation, so 17.5G is applicable. The next question is leasehold property. It's like a transaction where either no rental or a very minimal rental is charged. Initially, it is taken for a long period. A huge deposit sum of money, say 10 lakhs, 20 lakhs, or sometimes even more than that, is deposited. The owner uses the same to generate interest, which will be his income. And once the at the end of the period, the entire amount will be refunded back to the tenant. In the interim period, most of the time no rental is charged. There could also be a variant where a minimum amount of rental is charged because of the heavy deposit made. So in what we call as Kuttagai in Tamil, I don't know how it is in Karnataka. So whether this will be a taxable supply Entry number 12 exemption will not apply because this is for a commercial purpose. So it will be a taxable supply and RCM will be applicable on the market value of the transaction. But taxable value will not be transaction value. It is taxable under reverse charge. Entry 5AB will apply. But value for which you are supposed to pay RCM will be the value which is fixed at the beginning. RCM will not be, in my view, RCM will not be required to be paid on the full amount at the initial stage. RCM will be payable on the market value on a monthly basis. But still, I need others' views also on this because there are varied views which are coming up in this form of transaction. Anything to discuss on this, or shall I complete my presentation, sir?
Go ahead, go ahead.
So the next variation is long-term lease for more than 30 years. It's a direct long-term lease for more than 30 years. There is a specific entry. Sorry, there is an entry number is wrong. There's a specific entry for this. It's not a residential dwelling. Entry 12 will not apply. RCM will apply. Sorry, this I'll come back to this because the entry has already mentioned. Next case study is an empty site is given on rent for use as car parking by a hotel under regular GST number. So this entry number empty site given on rent for car parking, you cannot call it a residential dwelling because there is no structure on the land. It is only an open land. So residential dwelling entry will not apply. So it will become a taxable supply and it will be taxable under forward charge. RCM entry will also not be applicable because it is not there is no building structure as such.
Structure is necessary, yeah?
Sir,
From the notification.
notification uses the word residential dwelling. So I think a structure is necessary, sir.
Other than, no?
Other than residential dwelling, sir.
Other than residential dwelling is commercial dwelling.
That is my understanding, sir. So
Okay.
I'm not sure about land. Service by way of renting of any immobile property other than residential dwelling. Okay, so yes, 5AB it will can fall within 5AB also. Correct. Which means if the person is registered, then again RCM will apply. RCM will have to be paid. Again, farmhouse and lawns given for use by wedding planner. Here again, the usage is for a commercial use. So farmhouses and lawns given, there is a specific entry under 54 for agricultural purposes, it is exempt. So since the purpose for which it is given, it is not for agricultural purpose. entry number 54 will not apply. So it will be a taxable supply, in my understanding.
But farmhouse is also a residential dwelling only, right?
So farmhouse, can be called as residential dwelling. There is also another principle of uh, permanent versus temporary stay. So yes, even in that understanding, yes, farmhouse can be a residential dwelling. But will it fall within entry number 12? Services by way of residential dwelling for use as a residence. Yes, sir. Possible, sir. But the purpose for which is given is not residential purpose. So entry number 12 specifically uses the word for. I'll just display the notification also. It's easier. Sorry, entry number 12 under 12/2017 uses the word for use as residence. So when it is given for stay, then yes, it will fall. But when it is given for the purpose of wedding reception and all commercial purpose, I don't think it can fall within this entry.
Basically, I was trying to tell that it should come under reverse charge and not under forward charge.
It won't be a residential dwelling. Entry 5AB, registered person to any registered person. Registered person to be a registered person. Okay, sir. Possible, sir. Yes, sir.
Raghavendra, a big barren land is given for parking, given as a parking space for a group of individuals. Say
Okay, ma'am.
5 or 6 friends are there. They want some additional car park. I have one extra piece of land. Okay.
Okay.
I'm giving that for rent.
Okay.
Say per month, 3,000 rupees.
Okay.
Will it fit under a residential dwelling? I mean, it will not fit under residential dwelling.
It will not fit under residential dwelling, ma'am. Because residential dwelling, like what I said in the first, actual usage would be the criteria to decide whether something is a residential dwelling or not. So when it is used for a car parking, it is not for the purpose of residence. So it'll be a commercial purpose only. So it will not fit within entry 12 of exemption notification. It will be a taxable supply. And again, but it can, like Jatin sir mentioned, it will fit under 5AB. RCM notification by AB, it will fit, other than residential dwelling, because RCM notification uses any immovable property. So which means it will be a taxable supply under RCM.
Not a registered person.
Sorry, ma'am.
I am not a registered person.
Meaning tenant is not registered, is it?
Owner is not a
Owner, yes.
third person.
Owner is not registered. If tenant is registered, then RCM will apply.
Tenant is also not registered.
Tenant is also not registered, then even RCM entry also will not fit. But it will be a taxable supply, which means it will be threshold exemptions will apply. It will be taxable under forward charge. Once you cross the limit, then owner is the one who is supposed to get registered and charge GST and pay. Is it right, ma'am? Any other views?
Which entry will it fit in? 5AB.
No, ma'am. 5AB also it will not fit. So RCM will not apply.
Okay.
11, notification 11.
Any other view, ma'am?
Okay.
Ma'am, Annapurna ma'am, if it is 11, which entry will it fit in, ma'am? Under 11.
Yeah, I'm just sharing. One sec.
I'm also look, ma'am. If you, I can share if you want. I'm sharing. Just a minute.
16, no?
9972.
See, once supply levy fulfilled, we first need to visit 11 and then 12.
Yes.
Yeah, 16 residuary clause 3.
16 residuary is real estate services other than 1 and 2 above. Says real estate services will fit under real estate service.
To look for renting of plant and machinery, any other machinery. I don't know the entry number. Will not, but I don't think it will come under real estate services. Neither
Yes.
property. I'm sure there will be some entry, but not residuary.
We look at that annexure 99721 Has all that, no? Rental or leasing, residential, non-residential.
Connection.
I've shared that screenshot in the group, Raghavan.
Explanatory notes. I'm just reading the explanatory note on the 9972. 997211 reads as rental or leasing services involving own or leased residential property. This service code includes rental or leasing services concerning residential property by owners or leaseholders, houses, flats, apartment building, multiple use building that are primarily residential mobile home sites. This service does not include accommodation services provided by operating hotel, motel, room houses, school dormitories, campsites, and others.
Nine 997212, no?
Building, property. Parking vehicle by the month of the year.
Yenappa, what is going on?
Sir.
Everybody is
Nine-
silent. Everybody is reading. You discuss. You have read. What is the question?
Yes, ma'am. So
Ma'am.
parking lot given on rent, which entry, which HSN will fall under? So it will fits under 997212. Yes.
Okay. Anybody disagrees? Sujata madam had something to share. Okay, you proceed.
Okay, sir.
It's not directly fitting in, but probably I have to see. Just give me some time.
Reserve that point for madam to share her views.
Yes, sir.
That first one, Annapurna, I'm just looking at the WhatsApp, what you have shared.
Yeah.
If I look at it, then real estate services involving own or leased property, right? So 997211, rental or leasing services involving own or leased residential property. So
7212
the
is non-residential, no? Ma?
7211. So you mean to say renting or
Yeah, Sujata will take it offline now.
yeah. Ravindra, you please proceed.
Yes. So next case study is Temple Trust property taken on rent by TV serial producer. So it is a property of a trust, but it is not a charitable activity. So it will be a taxable supply, is my understanding. So next issue is whether any digital marketing company, it goes and hires places and fixes hoardings, whether such place of hoardings would be supposed to be added as additional place of business. is a common litigated area. So a place of business is a registered place of business. The registration is based on the place of business and not place of supply. So registration should be of the place from where he is conducting the business, not the place of holding. So all the temporary locations where hoardings are placed will not be required to be added as additional place of business, is my understanding.
Raghavendra,
Yes, sir.
why did you use the word place of supply for registration?
Registration sake, place of supply is not applicable. So place of business is the key criteria.
Isn't it place of supply as a thumb rule is always location of recipient?
Yes, sir.
So, when the advertisement services, let's say someone in Maharashtra is taking an advertisement of a billboard in MG Road, Karnataka,
Hmm.
is the place of supply is Karnataka?
If recipient is registered, then it should be recipient's place.
Right. So, just wondering that why did that word place of supply came from your mouth?
So that was for only for distinction between place of business and place of supply I had mentioned.
Correct. So, is the place of supply MG Road, Karnataka for the advertisement services?
No, sir.
No, you
So-
refer section 12 answer. Why are you guessing it?
Sir.
See, advertisement company is different from the company that will fix the hoarding and maintain it throughout the year in MG Road.
Hmm.
There is one company called Prakash Arts. They maintain outdoor assets. Whether there's advertisement to display or there is no advertisement to display, they will maintain the outdoor street asset as it is called. Bus stand furniture, skywalk enclosure, billboards, electronic display board in traffic signal. Those assets are installed and maintained throughout the year by company X. Company Y will take it for 1 month and offer for advertisement. Somebody else will actually put up the displays. Apple phone ad agency will say, marketing team will hire the ad agency. There are 3 actors here. There's Apple distributor, there's advertisement agency, there is outdoor asset company. Who are you referring to here?
Advertisement agency, sir.
Then under section 12, where is place of supply? They will put up the display wherever you pay money, whether it is on a fixed board or in the back of an auto. Or Uber car on the door, they will fix some sticker. Which one are you referring to when you say place of supply?
Sir, I'll check and get back, sir. I will have to think again.
Okay.
Raghavendra, probably you can just think of this scenario.
Yes.
Say for example, big basket. Okay, it has got some vending machines, right? Where you can pay and get whatever you want, milk or chocolate or whatever, right? If they install it at various places, what will be the place of supply? That vending machine. One in, say, IT technology in a software company, other one in an apartment, other one in some other on the road, railway station, various places.
I will have to think and get back. I'll get back on this point. Just a moment. similar point on this. Um, a person has an RC in Tamil Nadu. He has a temporary rental place, which acts like a common place where they pool to distribute the property. It is common in a dairy industry. It's an actual case. A person registered in Tamil Nadu, dairy manufacturing, everything happens in Tamil Nadu. Lorry carries the goods to one specific common parking lot or a small godown kind of place. No goods are stacked over there. The lorry goes there, and their other vehicles come up, and the goods from the main vehicle gets distributed to the other vehicles for distribution. They just stay there for hardly half a day or something, and they leave. Whether this can be treated as a place of business for the purpose of registration, whether it will be treated as a fixed establishment, either as a place of business or as a fixed establishment. So in my understanding, place of business will be registered place. It is not, no supply is happening from that location. So it is not a place of business. It is neither falling under a fixed establishment. So it need not be added as an additional place is my view.
What is basis?
Sir, there is no supply happening from that place. Can we say it is a place of business?
You're carrying one tanker with 2 tons of product. You're now distributing it to 100 people from that location.
Yes.
Where will you raise the invoice from? What if there is pilferage and out of the 2 tons or 1.5 tons only is available for distribution? Remaining is all spilled there only. How will you account for it? How will you move the goods from your central location in TN to that distribution point? It is not like you're standing by the side of the road and distributing it.
Okay.
Like,
so it will be a fixed establishment.
I'm not telling any answer. I have only got questions. Answers you have to give. Can you say that at that intermittent point, the goods are still in movement, or the movement has ended?
Intermittent
Movement
point.
is not journey. Journey is when the truck is moving. When the driver is stopping and at Daba, then journey is not taken place. But movement is still going on.
Okay, sir.
So at this point, when it reaches the distribution point, can you say that the movement has ended or the movement is still going on?
Movement is still going on, sir.
So e-way bill will be for a further location.
Yes.
Not at, so although e-way bill is for a different location, the vehicle has stopped here under the tree. They're unloading the goods and reloading it in some other vehicle. You're changing part B of e-way bill here.
Yes, sir. Part B, yes, sir. Part B will change because vehicles change.
2 tons are going to split into multiple autos and change part B, new e-way bill.
Yes, sir. It will be a new e-way bill, sir. Until here, this location, there will be one e-way bill.
Movement is ending here.
Okay.
Movement
so
ends.
Not going on. Okay, sir.
So now think about it.
So if movement is ending here,
how can it not be a place of business?
Yes, it will be a place of business.
But basic thumb rule is for, as per my understanding, is we chase the goods, right? Wherever it is, always chase the goods where it ends. where is the destination, right? So if that being the case, at the time of transport itself, beginning of the journey itself, you know that this destination is going to be under the tree, or what is that?
But a temporary, a small warehouse kind of place, a temporary setup. So in that case, it will be a fixed establishment, then registration, you will have to add it as additional place of business. So anything more on this case, sir?
இல்லப்பா இது உங்க கேஸ்
So, and another case, similar practical case, what happens is a transport operator registered in a location in Tamil Nadu goes ahead and purchases vehicles from Karnataka, and the local agent in Karnataka has given a fake address of his own and to register for the purpose of RTO registration. So whether since all the vehicles are under Karnataka address, whether Karnataka address can be taken up as a fixed establishment for the purpose of adding as additional place of business and other purpose. My view, no, RTO registration address cannot be taken as a fixed establishment because no substantive business is happening. All the vehicles are movement, everything happens only in Tamil Nadu, no, nothing in Karnataka. Only purchase happened in Karnataka. So my understanding, it will not be treated as a place of business. No registration is not required.
Suppose you are taking ITC on capital on the vehicle purchased.
Yes.
Okay, what tax they will, if you give Karnataka GST number, what tax the vehicle dealer will charge? CGST, SGST, or IGST?
No, sir. Tamil Nadu, there is no registration for the person in Karnataka. He is
No,
only
on
registered.
RTO you have given some number, no? So you will get KA registration or TN registration.
KA registration, sir.
KA registration, so you will charge IGST or CGST, SGST?
Sir, this
You
practical
are
case,
giving
what
KA you are getting KA registration. What tax the dealer should charge you? That's all.
it will be CGST, SGST, sir.
CGST, you will get ITC in Tamil Nadu for this.
No.
Tell me now, what is your answer?
Now we will have to, registration will be required.
Isn't it? Then how did you give that answer in the beginning?
Sir, I was thinking in terms of whether any supply or substantive business is happening from the location in Karnataka.
It may not be happening. You see all the Sivakasi lorries in Mangalore.
Okay.
You see all these Nagaland buses in Bangalore. Registration, for whatever reason you give address in one state, you cannot come and say, "Ayyo, adella tappu, that is all bogus. Actually, it is some other place." Can you say that?
No.
No, I didn't understand your question. What is it?
No, I want to ask Raghavendra. So first he said no, now he's saying yes. So just because there is ITC loss, now you want to say that there is a fixed establishment? Question to Raghavendra.
No, sir, not because of ITC loss. First, I was of the understanding that if there is any supply happening from that place or a substantive business happening at that place, then it will fall within place of business.
No, so I am a passenger transport vehicle or goods transport. I have a small rented premises in Nagaland. I have taken the vehicle as a Nagaland registration, but flying only in Tamil Nadu and Karnataka. Now, every time I am doing the trips, what do I do?
If you have an office in Nagaland, then yes, sir, it will be a fixed. It
No,
will
no,
be
I have a house basis that address. The registration happened in Nagaland.
okay. Then it will be liable. You have to get registration in Nagaland.
Okay. In
Yes,
the
sir.
earlier scenario, you said no
No,
registration.
sir, no, because in this case, the uh, registered person did not have a place of location in Karnataka at all. He is actually registered only in Tamil Nadu. What
Even in the current case, I don't have any business in Nagaland. I just purchase the vehicle and I come here and do the only business here, Bangalore, Goa, Bangalore, Goa.
Sir, in that case, if the address which we give for RTO registration in Nagaland, whether it is your own address or another address given by another dummy address, which would because in this scenario it was not the address of the recipient as such.
I don't
It
know.
was
What do you mean by dummy address? Only for the purpose of taking a vehicle registration, I've taken a
RTO.
property for 3 months.
No, sir, not even property taken. RTO himself had given some other address, location, some other address proof, and done the registration. It was not
Okay,
actually
consider
taken
I
out.
have taken a property on rent for 3 months, taken the registration, now surrendered the property. I'm here in Bangalore.
Then so business. If you have surrendered the property, then once you surrender, you can remove that. No, sir. Is that not
When you change
correct?
RTO registration of Nagaland to Karnataka, Tambi, as long as you have Nagaland registration, you have to keep on finding some address in Nagaland. Why Nagaland, you tell me? Why all buses are registered in Nagaland? Lesser road tax.
Okay, sir.
And at the time of registration also, if it is for commercial, yellow board, white board, all that will come into place, no? So there is a question of no registration. Forget about ITC. At that first instance itself, it will get knocked off, no?
Okay, ma'am. Okay, I was of a different. Okay, I was wrong in that understanding. Yes. So that is it with my case studies. Sir, any discussion on whatever we have discussed?
See, in between,
The
I-
scenario what Jatin sir gave, no, like three companies involved. Can we discuss a bit more on that? Like, what are the three services and what would be the implications for each of the three things?
Ma'am,
I think one would be a leasing arrangement wherein that hoarding the person owning that and would leasing it. Second would be the person who will be displaying on it. The third would be the
the actual person who is
no,
taking
the advertising agents. No, that is part of this thing, no? So service provider and service recipient. So
ma'am, I need to think more on it. Can I get back on this?
Raghavendra, on your house, assuming you are allowing someone to place a hoarding,
Yes, sir.
what would be that activity for you?
It will be a commercial activity. It is not.
Hey, how commercial ra? There is na. Sorry, sorry.
So now you will treat that as commercial renting of the property?
Yes. Yes, sir. I'll be treating as commercial rental means.
Okay. A guest house for the company, you would say that ITC would be disallowed, is it?
Sir, guest house meaning yes, sir, because it is not a permanent stay. So, my understanding, we cannot say it is for a residential dwelling.
Company has two options. Either whenever their vendors, customers come, they can book a hotel or place them in their guest house.
Yes, sir. It is temporary stay, no, sir. That's my
Correct.
understanding. Temporary
Yeah.
stay.
So, is the question is you are saying that 17.5G ITC is disallowed. I just want to get a reaffirmative statement of yours.
17.5G personal consumption. Just a minute, I'll read that entry. Goods or services or both used for personal consumption. So, when you say it is not for residential dwelling, it also flows that it is not for personal consumption. It is for a business use. Is that the understanding, sir?
Okay, I want to get your view.
Okay. Guest house.
Now, both landlord is registered and the company is also registered. And this is a residential building, and the purpose given to company is for use as a residence, not for commercial activity.
Use as a residence.
Yeah. It's a guest house. It's only for stay. So the rental agreement clearly says no commercial activities can be carried. It is only for stay, and it's a residential building. Both the landlord and the company is registered.
Sir, it is for a temporary stay. It's not for long-term stay. It's not for permanent stay. So I doubt the guest house will not fit within the definition of residential dwelling is my understanding. So if it not fits within residential dwelling, then it will be taxable. It will not fit within RCM entry. So the owner will have to charge GST. Company will have to pay GST. And ITC would be eligible in my view. It will not fall within 17.5G.
But the landlord saying that it's a residential building and I'm giving it to for residents as a residence use. Now, assessing as an assessing officer, how do you say that it is the commercial building? Wouldn't the rental agreement be basis for you?
No, sir. Rental agreement cannot be a basis. Actual business use is what is the basis. What is said in the rental agreement is permitted use. So my take is, while deciding a residential property, the actual use is what will take priority over permitted use. Maybe I might be wrong, but as of now, this is my stand.
What if it's not a company, but it's a proprietor who is registered under GST? What would you say?
If it is a proprietor registered under GST, then it would be
So what purpose is
what
using?
purpose is yes.
I have a tea estate in Coorg. I have to go supervise the tea estate. My people go and supervise the tea estate. I have taken a property on rent in Coorg.
For your stay, sir.
My stay,
Who is
my
it?
employees, my customers, everyone.
See, if it is for the stay of the proprietor, then there is a specific exemption in the exemption entry itself, entry 12. Just go and read this. Explanation 1. For the purpose of exemption under this entry shall cover services by way of renting of residential dwelling to a registered person where two conditions to be satisfied. Registered person is proprietor and rents residential dwelling in his personal capacity, not for business capacity. And such renting is on his own account and not that of the proprietary concern. So if it is only for the proprietor, then it will fit within entry number 12, it will be exempt. But if you are taking for the employees or guest stay or something else, then it will not fit within this entry. So it will be taxable is what I am coming at.
Got that. Yeah. As a forward charge in the hands of the landlord.
Yes, sir. Yes.
And if the landlord is not registered?
If the landlord is not registered, then it will be a sorry. Sorry. If it is, then we cannot. Is it for a residential dwelling? Yes. Any person, if the landlord is registered or not registered, then it will be under RCM only, not FCM. Sorry, it will be under 5AA.
So if the landlord is assuming a position that it is a residential building, so
Okay,
he
sir.
doesn't have the exemption, but it is under RCM.
Yes, sir. It is taxable, but it is under RCM.
So it is not to do with the usage of the property, but it is the type of the property.
So no, sir. It is with usage only, no, sir. We are talking from usage only, sir. Sorry, sir. Thinking again, RCM entry will not be under 5AA. So when we decide based on what is the actual usage, not what is there in the deed. So in that case, it will not be a residential dwelling. It will be other than residential dwelling. Then 5AB will apply. If the owner is not registered, then RCM entry will apply. It will be under RCM. If the owner is registered, then it will be under FCM. Renu, sir?
Okay, so my view is when a residential building is given for rent, but the usage is altered by the recipient. From the landlord perspective, it is an exempted entry. However, when it is given for the business, That means it is not given for the residential use, so exemption doesn't kick in. And it will be 5AA. The registered person would be paying under RCM. This is the recipient.
So the basis of deciding is what the deed permits. Correct, sir?
So the landlord should raise an invoice saying that it is under reverse charge and you pay it yourself, is my view. He would be raising an invoice, but he would be raising the invoice as if it is a reverse charge entry.
This is what we derived after that, what is it, Vasudev Ambarish, that case, no? All these amendments itself came after that. So first you have to test the intention, purpose, nature of service, then registered, unregistered, then you decide. So all three you have to examine. It is not just a straightforward answer. All three you have to examine and decide. So even if a company is taking it for commercial purpose, residential purpose, so the service provider is giving it for residential purpose. The service recipient is also using it for residential purpose. But he being a registered person, he is liable for RCM. The company has to go under RCM, pay it under RCM. So three things you have to test.
Ambarish case, ma'am. Sujata, ma'am.
Yeah, some movie actor.
This Tagar Vasudev Ambarish.
Tagar Vasudev
Karnataka High Court.
Ambarish.
Ambarish ella poyachi.
Oh, it is not that movie actor. I was thinking, no, okay. Tagar Vasudev Ambarish case. I remembered it that way, so I'm sorry.
Okay. So anything more, sir?
Raghavendra, I have a few questions.
Yes, sir.
Can you go to your case study number 11? Now, this is a leasehold property, huge deposit, no rental deposit return model. Long-term lease is what you are talking in this case, right?
Yes, sir. Yes, sir.
So when is the lease consideration, is the tax on that is liable to be paid? What is the time of supply?
Time of supply.
Consider example, I am receiving 5 lakhs for 10 years lease. At the end of 10th year, tenant will vacate the premises and I will have to return back that lease deposit to him.
Kuber, what is the question? Can you explain again a little bit?
The long-term lease, say for 10 years, I am receiving 5 lakhs in terms of lease deed today.
So it's a
It
mortgage.
will be refundable.
It's a mortgage. What is the supply here? Any taxable supply here? You gave 5 lakhs, you got back 5 lakhs.
Agreed, sir. So the premises are meant to be used by the tenant or the recipient of services.
So usufructuary mortgage. I have given you 5 lakh rupees. As security, I have taken your building. Till you repay this 5 lakhs, I will enjoy the building. What is the supply here?
Okay. Usage of building is the supply.
Incidental to the deposit.
Sir, but many a places we observe that the lease agreement, they call it as a lease agreement only and they take the security deposit, no, sir?
No, no,
Or the lease amount is being mentioned.
you're
Most
right.
of
You're
the,
right.
so
You
in
call,
those cases, how will it be considered, sir? Because
um,
there, one more point what I was trying to look at is, can we consider the notional interest itself as a one value for the purpose of arriving at the valuation?
see, notional valuation will apply only when 15.4 is triggered. But 15.4 is it triggered in all these cases? Notional valuation is all central excise.
Yeah, that's right, sir. I'm just trying to analyze, can this particular aspect get triggered is what I was trying to look at, or we'll have to take the open market value. So to arrive at the open market value, can we consider notional rent as one of the value for the
No,
purpose of
I'm only
arriving?
saying, first let us decide there is a supply. Then we will decide what the valuation of the supply.
Okay.
If supply itself is not there, then where is valuation? Can valuation, this is what is happening with corporate guarantee. There is no supply. They have come out with a valuation mechanism for it.
Mm. So then can we argue, so we are trying to tell that the usage of premises itself is incidental, but even though the document is calling it as a lease agreement, it is a usufructory mortgage is what you are trying to tell, sir?
Correct. Because if you say there is a lease and there is no consideration, then such an agreement is void. You know that.
Yes, sir.
So now we have to decide, is it a mortgage erroneously called lease, or is it a void lease agreement for lack of consideration?
Okay, sir. Yeah.
Kuber, over to you. You were discussing.
Yes, sir. Point taken, sir.
So, where, sir? Any other doubts, queries?
So, sir, if that be the case, then the agreement should also be drafted differently, no, sir? That it has to be like, I pay you some X amount of money and then with the condition that it will be repaid with no interest after, say, Y number of years.
You're right, madam.
In exchange, I am giving possession of my property. That's all.
You're right, madam.
It has to be carefully worded to avoid all this.
Sir, the intention of the parties should be read from the agreement. See, because agreement says it should be maintained in such a way, permitted, non-permitted use under interest-free deposit, and it should be repaid after this. It is all the wordings which will, just like in rental agreement. In those cases, can it be said that instead of paying a rent, that interest component has been disguised and a huge deposit has been paid?
See, they cannot substitute the fact with what appears to be reasonable to the department. What is more fundamental than GST is the rights of the parties. They cannot say it is a lease when it is in substance a mortgage or vice versa. They cannot cherry pick clauses and say this this looks like a lease. Ultimately, they have to say it is a lease agreement. Then they have to explain why there is no consideration in the lease agreement. Agreement without consideration will, you know what will happen. It's not easy for department to substitute the agreement. What do you say?
Okay, thank you.
Sir, there can also be situations where the deposit received is partially refundable.
So then the answer is obvious. In a mortgage, there is no partial repayment. No,
Okay, sir.
we'll take housing loan and then we'll repay only half the loan. See, then there's a risk if you do such things. There's a risk that the agreement will be treated as a sham. Then what Shekhar says will happen.
Jatin sir, in Bangalore, especially people taking properties on rent, there are two types. One is regular monthly paying rent, wherein you enter into 11-month rental agreement to avoid that registration hassles. Every 11 months it gets renewed. The other popular mode is taking an immovable property on a lease, maybe 5 years or 7 years, as the case may be. So even though they call it as a lease, now going by the discussion we had shortly, so it looks like all of them should be user-free. I mean, you user-free mortgage. I don't think they should call it as a lease.
You're right.
So that means this concept of lease, which is very prevalent in Bangalore, it's rampant in many places. Many landlords prefer this mode. They say, give me 10 lakhs, 20 lakhs, depending on the size of the property. And you take back after 5 years. No rental in between. Even though I call it as a lease, it's a proper agreement entered and in some cases registered also. But if this is the position, then the sub-registrar registering also would be a little questionable. Unless the state stamp act says even this kind of mortgage should be registered.
See, sub-registrars only is interested in collecting registration charges. Both instruments are stamped on the same basis as a mortgage only.
So it's technically a mortgage, sir. No, I think the terminology should change now. Even though popularly people call it as a lease, but technically it's a mortgage.
Because we are using Google format, we chartered accountants are downloading and giving it to landlord now. Who needs lease agreement? Lease agreement is needed only for HRA, RFA purposes only now. So we are the ones who are actually downloading all these things and giving it to landlord.
Yes, sir. Thank you.
Raghavendra, I think you need to change your comments to this case study.
Yes, yes, sir. Noted, sir. I'll change everything. I think many case studies there are changes. I'll update it.
Raghavendra,
Yes, sir.
just my only experience is I believe that this presentation is coming only now and not discussed in the group. That's my experience. Okay, nothing wrong. Just
Yes.
that if you would have discussed, the examples could be better. And I'm not sure, have you discussed with Siddesh on this or not?
No, sir. I had not discussed, sir.
Yeah. So the purpose we created the group leader is, and we allocated the topics almost now. For next 6 months, the topics are allocated. Its only purpose is to do research and discuss with the group members and the group leader, and then do the presentation.
Okay, sir.
And not for you, but for everyone, including me. Yeah. Any other question for anyone before we conclude?
So the question is that we are now having one from the supplier's perspective and one from the receiver's perspective, like the example of guest house which we were discussing. So it is always on the recipient's perspective, if RCM is applicable. Otherwise, it is supplier's perspective. Is it that conclusion we are deriving?
So I too have the same question what Deepak sir is mentioning, whether to put it in a different words, whether we can say that if RCM is not applicable, then FCM will apply. Correct, sir?
It is not either or, no, Raghavendra. When the law is given,
Not either or. Yes, sir.
it has to be followed as per the law. It's not
Yes.
like, okay, if it is no RCM, then FCM. If it is RCM, then it has to be RCM.
Because why this question come up, sir? Because there are cases where it falls under a taxable category, but it does not. Sometimes it falls under RCM. It does not fall under RCM. So the way was, if it is taxable, if it is under RCM, it will be RCM. Otherwise, we go to FCM. Is that the correct understanding, sir?
No.
The levy is under 9(1). There is no levy under 9(3).
Yes.
The tax levied under 9(1) is discharged by a different person through 9(3). If
Yes.
levy itself is not there, there cannot be a discharge under 9(3).
Yes.
So what are you saying? If it is not under 9(3), go back under 9(1), etc. Once it is 9(3), there is no forward charge. When it is forward charge, it cannot be satisfied by 9(3). There is no levy in 9(3), independent of the levy in 9(1).
Raghavendra, why the silence? It's like you understood, did not understand. Deepak's question is very clear. It's qua recipient or qua supplier, qua usage. How do we look at it?
Sir, I understand it partially. I will have to read it once again to get back, sir.
No. Jatin sir's statement, have you understood?
Yes, sir. Jatin sir's statement I have understood.
Done. Okay. Then you please come back on to the Deepak's answer. Maybe you can think over and come back.
I'll have to think over sometimes, sir. I'm not getting.
Yeah, but not later than the coming week. I want you to share the updated notes.
Yes, sir. I'll share within this weekend, sir. I'll update the notes and I'll share.
Just one more point here, like because the exemption is based on whether it is used for residential dwelling or otherwise. So it becomes an onerous responsibility on the supplier of such a building to monitor. Ultimately, it is used for what? I mean, so it will switch between exemption and taxability based on the usage, no?
See, Annapurna, if it is exempt, RCM will also be not there.
Correct. So if let's say like the document or the lease deed is worded for residential use, like the example you gave, sir, like that T estate. See, document is clear, like it is a residential use, so it will fall under 12. But later on, he is using it.
Where I am saying is, it is for residential use, but I'm giving it to the proprietary concern. Then the exemption would not apply. The moment we say exemption is not apply, I am again saying that it is not blindly forward charge. You still have to look at it, and in my view, that is also reverse charge. The proprietary concern would be paying under reverse charge, even if the supplier is registered. 5AA.
Yeah, see, like whether it is forward, reverse, we will park it for a while. So the point is here is whether exempt or taxable. Now, because of the usage change, like, sir was initially mentioning also address unauthorized use. Now, what is not permitted, he is using for that. let's say as per the deed strictly, it is permissible to be used as residential dwelling for own use. But he is in turn allowing his customers to use whatever, like in the example you gave. So it goes beyond the permitted usage.
Still, it would be exempt in the hands of the landlord.
How do we
He
say
is,
that?
he has given a residential building for use as a residence.
See, residence and accommodation services both have a different this thing. No, again, short term, long term. That thing pitches in here. So it is like, I mean, for a supplier, from the supplier perspective, it becomes a onerous responsibility for him to monitor the final usage of the property, irrespective of
Do
what
you
he
think the
permitted for.
recipient will give an permission till the lease period is done? Come and do the inspection. Lessee does when you have given the rights, relinquished your rights for that lease period, you can't enter into the property and you also co-enjoy, no, or occupy.
Correct. It is to the exclusion of the lessor. That is
Correct.
true. But the entry talks about usage for residential dwelling. No, so it flips between exemption and taxability based on that fine aspect.
Yeah. So document says that usage for residential building.
Hmm.
And I have not given to the proprietary concern, I have given to the individual person.
So whether he uses it or he makes somebody else use it.
Yeah, my view, it would still be an exempt supply.
So, but you are
Unless-
using the term, it is exempted from a supplier's perspective.
Yeah, the moment it is exempt, Deepak, it can't
Yeah.
become an RCM. An
Correct,
exempt
correct. So it is
supply cannot
exempt.
become. Yeah,
It is
gets
exempt, not only from supplies, the sub-service itself is exempt.
Correct.
Correct. So looks like they've not used exactly from whose perspective. They've said service by way of renting of residential dwelling for use as residence.
Correct.
So supplier is given for residential purposes. Receiver has taken it for residential purposes, but converted for commercial purposes.
Correct.
Okay. Now it is exempted from supplier's perspective. If it is exempted from supplier's perspective, that service itself is exempted.
Correct.
Then there's no question of RCM.
Correct.
But the facts, the actual situation is he's using it for commercial purposes.
Yeah, but the recipient is also not registered, no?
No, I'm coming from a perspective where recipient is registered.
The moment recipient is registered, your exemption entry goes off. Exemption entry also has an exception. You give it to the proprietor, not the proprietary concern.
Now, why are you using the word proprietor? It says to a registered person, not restricted to a proprietor.
Down the explanation. So if I am giving it to a registered person, then the exemption goes off.
Right.
So the moment exemption goes off, then I have to see between 9.1 and 9.3.
9.3, that is correct. So if that example of guest house given to a company or given to a proprietorship concern who is registered, will always get out of the exemption and will come under RCM.
Yes. Even though the landlord is registered, it would still be RCM.
Right.
Sir, Venu sir. So for basic question is whether for the purpose of deciding whether it is a residential dwelling or not, would you consider what is permitted as per lease agreement as the basis or the actual use as the basis? Which you think would be the first priority?
The priority would be first the building permission sanction, second building let out. So it is registered as a residential building, given it to use as a residential building. Both have to be satisfied.
So what happens to the actual usage then?
That isn't something happening illegally, no? It's like legally, this is what's supposed to be done. You are not doing as per the contract. That's
So
my
say,
view.
so say for example, there is a residential house. In Tirupur, there are a lot of residential houses, housing areas, which is not an office space to per se. For all EB, property tax, everything, it is a residential property. But there are buying houses, uh, um, agents who take the rental of the property, and they also get an NOC from the owner and get GST in that registration using that same registration.
So which means as a owner, I myself, I am allowing it to be
Allowing,
used as commercial.
yes, it is being allowed for commercial purpose.
Yeah. So where is the question? So it is used as a residence. It is used as commercial also. No?
So in that case, it will be
Ramesh, if
5A.
you go to the previous slide, so if you carefully read service by way of renting of residential dwelling for use as residence, actual usage they are not referring to. Use as residence, if you are renting, then it should be exempt.
So here, what the entry you are interpreting it as permitted use. For what purpose they are giving it as on rent? Is it, sir?
Correct.
Correct. Okay. Because my reading was it was actual use.
Now, how can actual use be different from the contracted use? And if actual use is different from the contracted use, will the contract prevail or the actual use prevail?
Might take actual use.
Then contract stands vitiated. So conduct of the parties have to be examined and not the paperwork that is done.
Okay.
Mylar?
Yes, sir. If the actual use, if the landowner come to know that actual use is different and it is then, and if the landowner keeps silent, then it is a deemed acceptance and commercial use was
It's a constructive modification of the lease agreement.
correct. Agree.
Now what happens?
Then it becomes taxable.
So therefore, use on paper, use on in reality has to be one and the same.
Yeah, if the landowner comes to know about it and
No,
skips.
he collects rent every month. He cannot say, I don't know. Once you take rent every month happily, you cannot say, I don't know.
Correct.
Okay, so now what happens to entry 12? We are trying to create a third category. Residential dwelling for use on paper as residence, for use in reality as something else. What happened at Tirupur buying house?
But therein the owner also is aware that it is for a commercial purpose.
That's all. You are not only in violation of GST law, you are also in violation of electricity supply rules and municipal taxes. Regularize all of those.
So any other queries, sir?
No, on this actual use, paper use, what happened? Kuber, Mylar, Annapurna, madam.
Sir, actual usage is without contract, sir. It's under implied contract.
Super.
Agreed.
So the onus would be on the supplier to take care of this, and definitely it would come back to him based on the actual usage and not the documented usage.
That's all. The burden of proof to claim exemption is on the person claiming exemption.
Yes.
Now, in a residence, not more than 20% is permitted to be used by advocate or doctor as a home office. Raghavendra Thambi,
Sir.
Unakadamba. There is
Yes,
a
sir.
2000 square feet house
Yes, sir.
in which 300 square feet the car garage is used by doctor as a clinic. Doctor lives there, clinic also in the same compound.
Yes, sir.
And what happens to RC? The municipal rules permit doctor clinic and advocate office in the same premises. It will not change the electricity meter or the municipal tax. Now, what happens to RCM?
Yes. So the joint property.
Raghavendra, you can consider single rental agreement. Ground floor is the shop, first floor is the house of the shop owner.
For a single agreement, sir. Okay. Will it not be a mixed supply? I think it will be a mixed supply and we have to segregate it and deal with it individually.
No, it's a single price. No, let's say I've given 1 lakh rent for the building. Ground floor is the shop, first floor is the residence.
Yes, sir. But it is for a single price, but it is not what to say. There is no principal supply as such. No, sir. One supply can be given independent of the other, is it?
So how do you segregate? You said you have to segregate.
Some logical basis, sir, based on square feet would be the logical basis.
Why would someone do and who would do that? Do you think the proper officer would do that? Or should he do that?
Ideally, the person should do and
no, I am the landlord. I have given it to you for rent 1 lakh rupees. I'm only telling you what I have done. The same with the Jatin sir's question also.
Sir, ideally it would be a mixed supply and treatment would be the landlord has to segregate it and treat it accordingly is my understanding.
No, in a mixed supply, you say that there is a segregation?
No, there cannot be segregation. Yes. Sir, no thoughts as of now, sir. I will have to check and get back.
Sir, according to me, it is 2 individual supplies.
I second this.
Oh, see, I think Jatin sir's question is slightly different than what Venu sir is saying. Venu sir is saying 1 floor itself is a commercial, but Jatin sir's question was only to the extent of permitted percentage of square feet that can be permitted use as per the municipal laws. In Jatin's question, the one rental agreement and that will be for a residence. But as per the permitted use, they can use it to the extent of that square foot for a commercial use. So for the Jatin sir's question, I think it is a residential. It will be covered as a residential. But if the Venus cells where the one floor was permitted for commercial, then there is a two supply in a one single agreement.
Similarly, in Jatin sir's question also, Namika, because yeah, of course, there is no bifurcation as such, but there is a separate area instead of a floor.
The agreement I'll give only for a residence.
Correct. Agreement is one, but
on the agreement I'll say it
usage-
is for residence. But because municipal law permits, he will use it the 200, 300 square feet for commercial purpose.
So there is clear demarcation and bifurcation of how much area is used for commercial purpose.
But valuation was another point where, see, commercial will always have a higher value. So ground floor, if you take, so it may not be on the proportion of the square feet. So there could be a variation in the valuation. So that also could be a concern. And how are you going to value it is again a challenging aspect. So probably we have to find out what is the value for the residential dwelling and remove that from the total value of 1 lakh what Venu was trying to tell.
But Shekhar, there is no provision in the law to do that, and it should not be done. That's what Raghavendra also said. That
No, that is right. I was just trying to see if we can give a thought on that aspect. Because Raghavendra mentioned that it will be done on square feet basis. So that cannot be considered was what my view was for that particular point, basically. That's all. And with regard to the leasehold lease agreement where the entire thing
Shekhar,
is
let's
given as a
complete this
long term.
conversation and then we'll take the next
Okay,
one.
okay.
So Mylar, you were telling like, since it is permitted, that permitted use impliedly gets covered under as per the deed itself. And unlike the previous example where we discussed that by conduct of parties, there is an implied contract lying in place wherein although on paper it is documented as residential, in actuality it is using for non-residential. So by implication that will prevail. But in this example, owing to the statutory permissions, he is using it for commercial, which is consented by the landlord, although not on paper.
Yes.
So how different is this example compared to the one we concluded?
Ma'am, you're asking about Mylar sir's question, is it?
Yes.
That's what, like Jatin sir example.
Jatin sir view.
Yeah. So Mylar, can you please share your thoughts?
No, we'll ask Jatin sir on it.
Madam, question ಹೇಳಿ.
ಸರ್ ಇವಾಗ ಪ್ರೀವಿಯಸ್ ಎಕ್ಸಾಂಪಲ್ ಅಲ್ಲಿ ನಾವು ಕನ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ದೇನಂದ್ರೆ ಬೈ ಇಂಪ್ಲಿಕೇಶನ್ ದೇವ್ ಅಗ್ರೀಡ್ ಸೊ ಐಡಿಯಲಿ ದ ಓನರ್ಸ್ ವಿಲ್ ಕಮ್ ಬ್ಯಾಕ್ ಟು ದ ಸಪ್ಲೈಯರ್ ಆಫ್ ಸರ್ವಿಸಸ್ ಅಂಡ್ ಇಟ್ ಈಸ್ ಟ್ಯಾಕ್ಸಬಲ್ ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ಬೀಂಗ್ ಯೂಸ್ಡ್ ಫಾರ್ ಅದರ್ ದನ್ ರೆಸಿಡೆನ್ಷಿಯಲ್. But in this example, what you've taken is it is being used for both partial because of the permitted statutory permissions available. Partial it is being used for commercial, but then on paper it is shown as only residential.
Right.
But landlord also knows about this. Aren't we required to treat these two separate?
There are two ways to read it. For use as residence, Is it a legal expression or a factual expression? For use as a residence, does it presuppose that in accordance with applicable laws, it should be used as a residence? Some people live in the office during tax audit season, some people live in the tree. It has to be what is legally recognized. And if legally there is a relaxation, unless this notification shows that the understanding under applicable law should be ignored, the understanding under applicable law should be taken cognizance of, because when the parliament makes any law, they are aware of the prevailing legal position prior to making of this law. So I would sense that you should ignore all permitted deviations under applicable law. Otherwise, this will become indefinite. You sit at home and do tax audit report, you sit and write opinion in the night at home. There's no end to this.
And will it also come like, primarily what it is being used for? That is not.
Make a rule out of it. For use as a residence as per applicable law.
So that wording not on the factual assertion, but on the legal, sir?
It's a legal expression.
Legal expression.
Legal.
Okay. Sir.
Does it maybe Kuber Maila, does it contradict earlier answer about implied amendment of residential lease?
No, sir.
All right.
Thank you, sir. Thank you.
Sir, on last video, when we were discussing about that leased property, sir, under this GST as well as service tax, there was one exemption for lease by KSSIDC or any state body. Then there was a certain exemption. So they had used the word in the exemption directly, they had used the word leasing only, sir. So what will be the impact of that in that particular case?
It was an exemption for leasing of industrial land, is it?
Yes, sir.
What is the question?
No, because we thought of that usufructory mortgage, no, sir. So,
correct.
So, but when we consider that as when the state body was giving it, where the state body had a transaction, means the state body gave the industrial plots on lease, then there was an exemption, sir. I think up to 30 years or something. I don't remember exactly. But
Entry 41.
Yes, sir. So that particular thing, what will it have? Because when there is a specific wording itself for leasing, then can we again tell that it is not a lease, it's a usufructory mortgage is what I was saying.
No. I am not saying call a lease a usufructory mortgage. I am saying if it is a lease, pay tax. If it is not a lease, don't make it a lease just because it has some of the characteristics of a lease.
Okay, sir. Okay, sir. Thank you.
Raghavendra, there are still some unanswered questions and we have to take a position, come back with the research material.
Yes, sir. I've noted everything down, sir. I'll get back, sir.
Yeah. And one point for others is in this session, be it amongst us, do not have looking good. Even if you are saying a wrong answer, you be bold to say your view. It's okay to get shoutings from Jatin sir or others, so that this is for learning. So don't withhold your say that, okay, what will happen if I say a wrong answer? But at the same time, don't just open the mouth every thought that comes to you.
Light venu nang baidnalla ivaga.
ಎಲ್ರಿಗೂ ಸರ್
Light ಆಗಿ okay. Okay.
It's just that I'm telling others, do work and be here. That's all, sir.
Right.
It's like between Annapurna, Srikanth and Mailar. It's like Mailar was hesitating to give an answer. Okay, let Jatin sir give things like that.
No. First I gave an answer, then.
Yeah. Thank you. Thank you, Raghavendra, and thank you, everyone. Nitin sir, thank you for being there. Sir. Thank you, sir.
Thank you.
Bye.
Thank you all. Bye.
Thank you.